Previously, we talked about schedules. So this is kind of all of the 100 series for DOT. And we're going to talk about the 108 section of scheduling. Dispute resolution, like I said, came out of the need to enforce the contract and notification provisions and other things that are there, as well as an interpretation of substantial completion. All the elements kind of go with scheduling, and the interpretation of substantial completion is on the Wiki site already. It is in your slide deck as well, so make sure you use that as a resource. This particular class, we have a lot of HAR and law references, so I kind of like it as just references and where some of this material is coming from. So disputes, what not to do. We're going to talk about a little horror story. Why should they be solved? What the engineer's decision means, what that authority means, and then we're going to go through, we'll probably spend more time going through the dispute resolution policy that was rolled out a little less than a month ago, or about a month now. And so I know DOT is just getting used to it, so we're going to go step by step through that policy. And if you've noticed, there's a part 2 to this. The part 2 is actually going through the calculations. So that is part 2 of this class, and I believe Brandon had put the dates out. Okay, so disputes. What not to do? What is a dispute? Why do we have disputes? I kind of want to get your feedback on what disputes you guys are dealing with, and we're going to start off with a little horror story. NTP was issued, so we're going to set the stage and then talk a little bit about why this is a horror story and where it started, where it ended up. What do you guys think should have happened? So there was NTP, Notice to Proceed, was issued in August. Within the contract, there was a time delay allowance that the contractor wrote in $30,000 a day. The specification basically said any owner-caused delays would allow the contractor to recoup and draw down on that allowance. The plans and specs at the time in August were incomplete, and there were no third-party signatures that had been obtained at the time of NTP. December of that year, a project engineer sends an email to the contractor saying, hold off on submitting shop drawings because we have new revisions and new sheets coming. In January, the contractor is pretty much complete with their pre-construction submittals that were required before they could start work. So they had started mobilizing. They were doing their submittals. Pretty much in January, they're ready to go. There are 2 outstanding comments on one of their submittals, and that's it. In February, there were significant changes in the plans and specs. And what further complicates that is there were no annotations to tell the contractor what the changes are. So imagine you're the contractor, you get 2,000 sheets and you don't even know what's changed and not changed because there's no bubbles, there's no revision annotation in the plans. So that's what sets the stage. Again, keep in mind, the NTP was issued. Contractor has mobilized. They're ready to start construction in January. Months go by, the contractor puts in a request for compensation, draw down on their delay allowance for overhead costs due to the time it's taken to rectify the significant changes that were issued to them in February. Their initial cost proposal and breakdown was for $1.5 million. Many months go by. Let's just say 12 months continue to go by. There's a project managers meeting held. There was no resolution at the staff level, so it was elevated to the deputy at that time. And top management tells staff to settle for 1.5. That did not happen. The change is outstanding yet. I think earlier this year, there were write-ups regarding this change. So my question to you, 2 questions. One is, how much do you think the contractor is owed, if any? And what do you think the settlement is now? So let's start with the first question. So what do you think? Based on the information you have, does the contractor have merit for a delay claim? Would you approve 1.5 million? What might you do?
I think when the top management mentioned to settle, they should have settled by then. I'm not sure why it took longer. I don't know.
The staff basically just didn't do it. They just kind of ignored the direction. And what probably further makes it interesting is this particular item went to mediation, and the people of course the contractor had been in that meeting where the top management was told to settle. And for some reason, the people that were fighting the change did not know that. So when they went to mediation, they heard that the deputy had directed staff to settle it because the contractor told them that had occurred. I mean, overall, sometimes these disputes, in my experience, become communication issues, misunderstandings. So what do you think? So we got one answer. Charles, where are you from?
DAGS, project management.
Yeah, you guys listen to your management. Good job. Not everybody does. That's kind of where this happened. So, and again, miscommunication for whatever reason, nobody understood that direction had taken place, but the contractor, it was actually at an elevated issues meeting. So there were meeting minutes. So I'm not quite sure why that information never got passed to they had a whole legal team that was working on it. Okay, so we have one answer, should have settled at 1.5. Anybody else? What do you think? So now you understand, okay, the direction happened, contractor told them, they went to mediation, that didn't work really. What do you think they're settling for now?
Were there ever any annotations shown that was the change from the bid set?
So the annotations were not in. So for whatever reason, the designer didn't turn on that layer or something. They weren't fixing it. And what further complicated it was some of the changes were like font changes. So you had to go through every sheet to figure it out. So both teams, so the owner with the construction management team, as well as a contractor, had to do Bluebeam matches to figure out what the changes were. So if you recall, when we did proactive project management, we talked about being fair and reasonable. So when those changes were issued in February, there was a request of the contractor, give us a cost proposal in 15 days. And it was kind of like, it's going to take them more than 15 days to figure out what the changes are. Is that fair and reasonable? So what do you think they're settling for, hopefully this year or next? Well, it's probably next year at this point.
Does everybody understand that thing at the top, the $30,000 a day?
So there was a time allowance pay item basically in the contract that said if the owner delays us, we get $30,000 a day. They didn't have to submit any backup. It was just written into the contract, just like you would write mobilization or whatever other pay items. So that was in their contract.
Hi, this is Joy with DAGS over in Hilo.
Hi.
Going back to the first line, knowing fully well that your plans and specifications are incomplete, why would you agree to the $30,000 a day?
That's an excellent question. At award, I think there are a lot of issues with all of this, but at award, even to substantiate $30,000 a day, you would think you would ask for something that substantiates that rather than just a line item written. I think that the thought behind this was there were so many other delays that had taken so long to resolve. It took years to negotiate what delays and escalations were. They had gone through this nightmare of delays that they thought, well, this is one way we can fix that we'll just write it in there so it's not going to take us years to resolve it. With those intentions, of course, good intentions, trying to solve issues quicker. I think what transpired was almost incentivizing the contractor to kind of manipulate the schedule and cause these delays. So I think that's where I don't know. I mean, why even if you don't have complete set, why would you issue NTP? So there are a lot of communications that weren't occurring. I think the design section said any day now we'll have plans, but like you see, it went from August to February, so it wasn't any day. It was a lot longer than any day. So lots of miscommunications, which is why, in my perspective, the contractor had merit for the delay. The question just becomes, what's the value? So now, years later, what do you think they're settling for?
30,000 a day per day.
Okay. So what would that total be, do you think, just rough numbers based on the time that you have here?
From August of this year to now, so approximately 90 days, like 2.7 million.
So we
Am I
got
not-
1.5, we got 2.7.
I'd say 2.5 million.
2.5. So the settlement is around 9 million. It has not been finalized. The write-up was done earlier this year. And the point of the horror story is to say the sooner you solve and resolve issues, the cheaper it is. When it goes without being solved, there's escalation, there are other issues, people get entrenched in their position, it never gets better. And I think sometimes, these numbers that we're talking about might be a little different than numbers you deal with on a daily basis. But if you take, even if your number is $3,000 a day, those numbers don't get better as time goes on. So disputes arise because of disagreements between parties on a contract. They could be perceived or real violations of the contract and obligations. And so, like I said, I think there were some major miscommunications on this. Not everybody had all the information. And so that's what we're going to talk about. How are we going to deal with that in the future? How are you going to deal with that on your projects? For DOT highways, how do they do that and navigate through the dispute resolution process? And what does that mean? So again, in part 2, we'll put numbers together. But why are there disputes? Lack of understanding and communication, number 1, I would say. I think sometimes we get entrenched in our positions and we start failing to listen to the other person to look at how we can solve it. Vague or ambiguous design details, contract language. How many plans and specs do we have? Inadequate or incorrect design data. How old is the design? Sometimes the information has been there for a while. Maybe we should be refreshing it. Third-party coordination or misunderstandings. Utility companies may change their minds, or board of water supply, things like that. Lack of adequate manpower and equipment available to the contractor. That could be marketing conditions, or people right now, I think, are super busy. Poor planning. They don't have enough people. Maybe they don't have experienced people on either side, or there's changes in personnel due to some of these issues. So I'm curious, what issues might you be dealing with? What kind of disputes do you guys see on a daily basis? Where are your communication issues, or where are you having disagreements, whether they're real or perceived? Okay, so what are you guys dealing with? Anybody have disputes? Everybody has perfect contract. Nobody's just agreeing on anything. These are just some issues. These are why issues happen. Personnel shortage, new employees, lack of understanding of policies and procedures. Absolutely. So what does that cause? What kind of disputes does that cause with the contractor? I know sometimes we hear the contractor doesn't understand things, right? So there are disputes due to that. Misunderstandings in the plans, misinterpretations, all of these things lead to disputes. Is anybody dealing with misunderstandings on permits? Here are some examples when we were working with the DOT Highways Working Group. Delays getting the contractor access because of right-of-way. Again, third parties maybe not showing up when we assume they are going to, or maybe our assumptions are incorrect. So when we're dealing with that particular issue, it's not happening the way we planned it. Contractors have concurrent delays with the state. Maybe they don't agree that it's a concurrent delay, so you have issues or disputes born from disagreements. And like Joy said, loss of productivity. Maybe you just don't have the personnel to run projects. Acceleration, they think they're being accelerated. Maybe you just think they're supposed to be doing it. Differing site conditions is one that happens a lot, right? Whether it's a differing site or not, whether they should have known that. Was that a correct assumption on their part or your part? Changes in the scope, suspension or termination of work. There might be a disagreement on entitlement when it comes to that. Variation in quantities, weather, whether it's a weather delay or not. Those kind of disputes. Errors and omissions, conflicts in the drawings, like I said, maybe outdated information, outdated references or loopholes. So that was actually, going back to our horror story example, that was one of the disagreements. I hadn't talked about this in other classes, but this time allowance was for 30 days. And so there was an allowance for basically $900,000 for 30 days. But the spec was written, it didn't cap it at 30 days. It said any delay caused by the owner would be paid at $30,000 a day. Actually, what I wanted to do was do a change order and take that section out of the contract and just make it a unilateral change order. And nobody agreed. They thought it was a cardinal change to do that. And I was kind of like, well, let's have that discussion. Let's have that argument. But when it's in the contract, to me, it's very clear that they have merit for $30,000 a day. So when we talk about this kind of stuff, there are a lot of ways to solve it. And that's why project engineers, I mean, I guess that's the fun part of being a project engineer, but you have a lot of discretion in how you do that. And that's where we're going to talk about the engineer's decision and how much responsibility comes with those decisions. So those are some disputes. Again, a horror story. To me, bottom line, the dispute never gets better. It always gets worse. So why do we need to solve those? That's the next section. We'll have a little discussion on why should we solve it. We talk about timeliness and teamwork, and it's in the contract. What are the costs associated with not solving it? So in our example, it was 1.5. We had administrative direction, and the contractor was in the meeting for direction to issue a change at 1.5 million. Well, it didn't happen. So now that's closer to 9 million, and we'll see once it's actually issued what the final amount is. So timeliness is important. We talk about notification requirements in the contract. Silence implies consent. And so it's never good to bury our heads in the sand. We always want to make sure we're tackling these issues in a proactive manner. And if they haven't reported it, but you feel like they think it's a change, address it in your weekly meetings. So we don't want to be silent. We want to make sure that we're addressing things, because a little snowball can turn into an avalanche by the end of the project if we haven't proactively solved it. So going back to our 101 class, just a reminder, it's all about golden rule contracting. And I think the tough thing in our horror story example, I think, Joy, you asked a perfect question. You know, why would they issue plans that are incomplete? Why would they then issue revisions that are incomplete? If you take that story to court and you look at it from a reasonable person perspective, it's going to be very difficult for a judge to rule in favor of the government with those facts standing out there. So I think that's why the contractor was very confident in the case that they could build if it ever went to court. So we want to make sure we're working with the golden rule, treating them how we would want to be treating, being fair, working as a team, timeliness, again, taking actions when they happen. I know sometimes we get busy with things and we put it off. I am just as guilty as anybody else, but we got to make sure that we're getting agreement, documenting those agreements so that we can move on. And we want to be honest, fair, reasonable per contract, and just keeping in mind that that's a requirement. For our DOT highways, it's actually part of the contract in 108 that we act in a civil and honest manner in all of our dealings. And the engineer, where we talk about who the engineer is, may direct removal of workers that do not carry out their work in a proper, skillful manner, that are disrespectful, intemperate, violent, or disorderly. If they're lying, if they're not working as a team, there are repercussions, or there is a tool for the government to use to dismiss those people if that's happening. So not only is it something we want, it's a contractual requirement. Of course, you work with their supervisor to see when it's appropriate to do that. You also, if there is federal funding, there's a False Claims Act. It's actually illegal for the contractor. I had one contractor actually tell me, well, it's my job to lie to you. And I said, actually, it's not. It's illegal for you to lie to me. So if I ask for your breakdown, you need to give me your honest breakdown. You can't give me false numbers. That's the false claim. I've actually gone into meetings reading the False Claim Act to the contractor to remind them that they are not allowed to lie. They have to conduct business in an honest and professional manner. So why do we care? What is at stake? How many of you, and just chat it, have dealt with a big dispute? Do you know what the costs of those disputes are? So everybody will react differently. So this comes from productive conflict. How should we react? So when we start getting in those disputes with people, we have a natural tendency maybe to act in a destructive manner. So on the outside of that circle, you'll see the destructive tendencies where somebody becomes overly emotional and they talk, they become impulsive, maybe they gloss over the tension, but we want to make sure we're communicating with empathy, encouraging open dialogue, providing assurance and verbalizing emotions, civilly and verbalizing issues. So Charles is saying he's experienced issues, but no big costs. I think sometimes, again, we look at costs, and on a project, if you're dealing with a $100,000 project, $3,000 starts to become 3% of the project. So they're not big numbers, but those numbers are always a cost, basically. So what might go into those costs? We want to start looking at a risk analysis. And so that's what we're going to work through in the exercise part of part 2. What is that risk analysis? There are some very basic costs. There's construction costs, your direct costs. There's overhead costs, but there's the cost of building a case. That can translate into time. Preparing documents, that takes time. If in our horror story example, somebody had gone through to get all the meeting minutes and read all the meeting minutes to understand everything that had to do with that particular issue, maybe the communication would have been better, but there was a cost in time and personnel that would have to do that to do that exercise. There's this negative impact on a relationship with another party. There are inconsistencies across districts throughout the state, right? So when those inconsistencies exist, you can start exploiting, or the contractor could start exploiting those differences. There are legal issues that take precedence, and there are distractions from finishing the project when you're not working together. So the bottom line is, when you really start elevating these issues, they always say the lawyer's the only one that's winning. The lawyer's the one that's going to bill no matter what you do. And really, is it worth the trouble to get half a car, basically? We want you to start thinking about that. What does that look like? What does that mean? What are those numbers? Because fighting to be right is not really going to get you anywhere. I've had people say, well, if we had just stood our ground, guess what? The contractors are there to make money. They're going to stand their ground too. They probably have more data with what the costs are actually costing them that they could provide in court. So we want to make sure we're not digging in just to be right. Fighting to be right is never going to win. You're still going to have the issue, and it's so much easier to elevate it, get it resolved. However, but again, we don't want 1.5 to build into 9 million. So once we start doing that, there's going to be a risk analysis associated with this. So if it's a low risk, and so on one axis we have impact, the other axis we have likelihood. So we start looking at what our risks are. Are they going to happen? Are they not going to happen? And as we get further into the matrix, you can see extensive management is required. And I want you to think about your supervisor. Once you start getting into a situation where extensive management is required, what are they going to want to do? Are they going to want to read all the meeting minutes and check over your paperwork, or are they going to want to solve the issue? Because they have all these other things pulling at them, right? So be empathetic with the position that those solve the issue might be dealing with. And there will be other factors falling into their decisions and why they are doing what they're doing. We talked about focus on other projects or that project. if you're focused on that project, your supervisor might be focused on 10 projects, and their supervisor might be focused on 30 projects. They're going to start weighing all of those projects and the necessity to solve this issue based on everything else they're dealing with. So extensive management becoming essential probably will start to encourage them to solve a dispute, and maybe it won't be solved the way you necessarily would want it solved. You start to lose control of your project. And so we want to solve issues at the lowest level. Of course, you're always keeping your supervisors informed, bouncing these things off of them. But once it leaves your control, you have less control. And so you can't have total control and not solve the issue. I think that's the overall message. So this is what kind of happens when we get claims and disputes. The contractor has an issue, it goes to the owner, there's a disagreement, it keeps going, right? Or we solve it, it becomes a change, it's solved at the lowest level. So disputes should be resolved as soon as possible so you can continue focusing on the project, reducing overall cost overruns and delays, and avoiding escalation of the relationship. So Marvin says sometimes those at the bottom cannot resolve due to authority over funds that may not be available. Okay, so I would challenge you to think, if those funds aren't available at your level, they're not going to be available at the next level either. So again, if you can solve it, and you can tell your supervisor, I need XYZ funds. Again, you're not doing this in a vacuum. You're informing them. In your case, it would be the RE. My understanding with Oahu District is the RE has become the delegated authority. And so there's always a way to solve it. And that's the message.
This is what Joy is also saying in her comment above.
Yes.
So understanding when to bring management in.
Yep.
And that's what this is about.
So again, you want to solve it if possible. Sometimes I've heard people, and again, it was the horror story example. There was so much disagreement at the staff level that it was elevated so that direction was provided. But again, because there was disagreement at the staff level, instead of doing what they were directed to do, they ended up just ignoring management, which in the end was to their detriment. It actually gave the contractor basis for more delay claim. Okay, so we talked a little bit about disputes. We talked a little bit about why they need to be solved, just like Marvin and Joy are saying. We want to make sure supervisors are involved. And with the dispute resolution policy, it gives you some guidelines on how to elevate issues. Again, it's very new. And so people have that discretion, but there are kind of triggers within the policy that tell you when you should be elevating these things. So the next section we're going to go through is the engineer's decision. And this is really important. Again, very focused to highways. My understanding from Chris, she was on earlier, your specs are similar. And so we just want people to understand who has the authority to make these decisions. Sometimes we're not in a position to make decisions, but are responsible providing recommendation. Yep. So basically, we're going to talk about the documentation required to elevate these decisions, and you working with your supervisor, what is and is not appropriate based on the authority that is delegated to you, if in fact it's delegated to you. So we're going to take a little deep dive into the DOT highway spec. So 105 talks about authority, and it says the engineer is a representative of the director and has all the authority of the director with respect to the contract. So that's a lot of procurement authority and responsibility that's being delegated. So what does that look like? It goes on further to say the engineer will make decisions on questions that may arise regarding the contract, such as but not limited to interpretation, materials, manner of performance and rate of progress, acceptable fulfillment, whether that's materials being provided, compensation. The engineer's decisions on all questions, claims, disputes are final and conclusive, subject to 107, and 107 is the claim. So basically, you have been delegated, depending on what that is, you have been delegated certain procurement responsibilities under the contract on behalf of the director. So you do have the authority to make these decisions. I think Charles is saying sometimes some people, upper manage, have hard time listening to lower persons. That's true. And this is why with highways, there is a dispute resolution policy with some very specific actions called, and the engineer being one of those actions. Who is delegated this? So in everybody's experience, who is the engineer? We just said the engineer is almighty, powerful, final, and conclusive decision maker. Well, now who is that person? And if you don't know on your particular contracts, it's probably pretty important to figure that out. Isn't the engineer the resident engineer? So for Highway O, my understanding at the pre-con, what they've started doing is saying that the engineer is the resident engineer.
And also documenting that in the pre-con minutes.
Right. So, because keep in mind, if it's not documented, it doesn't happen. So I think sometimes there's an assumption of who the engineer is. So if you're the project engineer, I think it would be really important for you to have something documenting who that engineer is. So if it's in your pre-con and you've communicated that to the contractor, great. In 101 in your contract, the engineer is a highway administrator of the highway division or authorized person delegated to act on behalf of the administrator. So that's where with the Oahu district, that person is the resident engineer. So my understanding from DAGs is that person is the administrator. And so if you're running projects, to me, my opinion, it would be important if you are the one making these decisions to get something delegated. The administrator may not delegate everything. They may delegate part of it, but it's important to have that piece of paper so that it's very clear what your responsibilities are. So what's Marvin saying? Long ago, the interpretation meant to describe to the contract the engineer, which meant the engineer all the way up to the chain of command, depending on the dollar amount. However, that has been muddled and misinterpreted, right? So that's one of the reasons we need to be very clear. And you're right, that delegation could be for certain items. It could be for certain levels. And again, my understanding from Oahu district, we haven't gotten that same clarity from the neighbor islands just yet, because it may be the construction engineer. They may retain it, the district engineer, we don't know. So it'd be important, and I think they're thinking about, one of the next modules is going to be diaries. The next module will be pre-con, so that we can talk about how everybody is doing this statewide to make sure we're consistent. But through each district, that delegation might be different. And it's important when we look at the dispute resolution policy to understand what that delegation really is. So one of the things we want to be clear about is you're not carrying this load alone, that you have the authority to do these interpretations, but throughout, again, we're talking highways, throughout highways, there are resources at your disposal. Of course, your supervisor being the first line of resource. And again, as we talk about the dispute resolution policy, that gives you the ability to reach out and make sure everybody's on board with what's going on, what the engineer is experiencing. So keep in mind, you've got your district engineer, you have DOT contracts office, you have the state procurement office, and you have highway CC. Again, this is highways kind of stuff. So the district engineer should be informed if staff wants to reach out to contracts. So we have talked to contracts office. They're more than willing to help you do a third party interpretation. Of course, we want to make sure you've written up the information, and we'll talk about what that documentation should look like. They can initiate a request for legal services to the AG's office. I think Highways Division, Ed wants to make sure he's involved before it goes to the AG's office. They can advise on contract interpretations. So just know you have that resource at your disposal. Of course, you want to make sure you're letting the district engineer know. Use it if you need it. You also have State Procurement Office, has a lot of little classes, and they actually have an issue in tracking escalation at this website. So of course you want to, and it says everything we're talking about, contract manager should attempt to resolve the problem at the lowest level possible. And that's what we want to see. At the same time, if problems are severe enough, legal representation may be necessary. So I think there's sometimes an impression that we settle everything, we don't want to go to court, and there is a basis for that. But as long as your documentation is good, which I think Blaine was saying, we need to be responsible for providing recommendations, make sure we have our backup documentation. And again, that's part of the risk with this, right? There's time associated with putting all that together. So you have to weigh that. I think that's where Joy is saying, you know, you have to understand the discretion of when to elevate and when to not. And that's part of the beauty of being a project engineer is having those challenges and understanding what that means. So this is also from the state procurement issues, tracking escalation that the contract administrator must act to address these issues. So same thing that we're talking about, all of these references say the same thing. So let's go to the procurement office. Under HAR, it is actually part of HAR that it's a policy of the state to try to resolve all controversies by mutual agreement without litigation. And so there is a basis when people say we settle everything. There's a basis for that under the law. I don't think that means give everything away, but that means do your best to weigh and look at that risk analysis and quantify those risks and understand at some point, if you're just hitting a wall at every level, and if you really are going to court, then you should start weighing that amount with what you're looking at. And that's the part we'll talk about in part B and look at what do those costs look like? What does that mean? Agencies are strongly encouraged to engage their deputy AG when a formal claim is received. So again, this is referring to the law. And so it's a lot more than our contracts, right? It's actually part of the state procurement process. And of course, when we get to a claim, you want to engage your AG, but we're hoping before you get there. I know Ed's perspective is you're not asking them what you should do. You should have your recommendation, all your backup, like Blaine is saying. You have that ready. You need it ready before you go to contracts. You need it ready before you go to the AG's office. That becomes this whole risk analysis that we're talking about. Okay, so now we're going to take a small break. We talked about what disputes look like. We talked a little bit about why they should be solved. We talked about your authority as the engineer, delegated from the director to the highway administrator to somewhere within your level. Maybe it's you, maybe it's your supervisor. You got to make sure you understand that so you understand who the engineer is, because in the dispute resolution policy, we actually talk about the engineer. And so if you don't know who the engineer is, make sure that that muddled misinterpretation is cleared up on your projects so you know who the engineer is. Like I said, I think on Oahu, they're saying it's the resident engineer, but it should be in writing somewhere. Worst case, write an email or a letter or something to your contractor so there's clear understanding. The rest of the time, we're going to talk about the dispute resolution policy that was distributed for highways and what that looks like and how you're going to prepare for that. Any questions on all of this? It's kind of setting the stage.
Yeah.
I know some of you guys that have tons of experience, you know this stuff. I think the dispute resolution policy will be a little different.
Well, and it does tend to follow what the state procedures are, that chart that showed the steps to take. We're mirroring a lot of that, but within our highways unique way of doing things.
So in under resources on the Wiki site, you have the construction procedures. And so this latest memo and dispute resolution process is here. It should have been attached to your meeting invite. And so if you haven't seen this, That's the last part that we're going to go through. Again, it's almost like the informal elevation process between when we have an issue and the formal claim is what we've laid out here. And we did take time to go over it with the working group that it has been assembled, as well as George, Ed, and the district engineers. So everybody is in agreement on this policy, and we're going to go through it right now, step by step. And like I said, it's, what is that, October 16th? So it's about a month old. And so obviously not everybody is going to be doing everything, but that's what we're working towards. So there is a flow chart in here and how the process might be navigated. And I'm probably going to repeat stuff that I'm going to talk about in the future, but it was important for the working group and to allow for their opinions and thoughts to be included in this process, that the engineer being referred to in the standard specs, so again, depending on what district, what level, that sometimes that's the project engineer, is part of the dispute resolution process. So part of this is not jumping past the engineer, the quote unquote engineer, that it's being referred to and following this process. And I think that was a big comment that came from the working group. Management had agreed to support this. So if contractors are seeking resolution without following the procedure, the contractor will be referred to the appropriate level in the dispute resolution process. And so hopefully this will help people not jump around, not get frustrated with you or your resident engineer, whoever the engineer is, and then go to ART. You know, we're supposed to have it solved at your level. And if you can't solve it, it actually becomes a meeting with the construction engineer and the district engineer, so that happens through the district. And then if it can't be solved at that level, we're going to go through the next steps and what that looks like. So it is on your Wiki site if you lose track of it, and just keep in mind all of these interpretations. At the very beginning, I was talking about substantial completion. So we do have an interpretation there. The next one's going to be force account. There were some questions on force account. So again, the intent is to provide statewide consistency on how these things are being implemented. So there's statewide consistency. That's what it is. That's what it's about. We're going to start to introduce the exercise that'll be part 2 of this module, dispute resolution policy, how to prepare methods of settlement. So again, here's where it is on the Wiki site. At the very bottom, this is the site, dot.wiki. So there is no .com, it's .wiki. This is the password. So everybody has that information. Alan's been chatting it as well. So the very beginning, the intent of this procedure is to proactively manage disputes while creating an environment of partnering, cooperation, open communication, again, keeping in sight that it's for the mutual benefit of completing the project. We don't want these issues to linger. We want to solve them. Remember, costs just go up, risk analysis just goes up, so we want to make sure that we're solving it as quickly as possible. The engineer shall inform their supervisor of all project issues as they arise. Management will refer disputes that have not followed the procedure back to the engineer for resolution, again, depending on where you are in the process. The point of this is to resolve the dispute quickly, and keeping in mind that issues or solutions that may create precedence on other contracts or are inconsistent with statewide practices are also issues that should be elevated. I think that's going to be one that might be a little bit uncomfortable, and you may not know when it's happening, but hopefully the construction engineers understand. Because if there's direction within Oahu district, let's just say, we want to make sure if it's something that's going on that everybody is involved with it. So we want to make sure those issues are getting elevated as well. Okay, so this is number 4, and this is the big one, and it'll be interesting to see how this plays out. But this was, again, a culmination of direction that occurred with Ed and George and everybody else. Okay, so the big kicker with issues, disputes, again, things that may not be in concert with statewide consistency, 2-week time frame, or has potential exposure to the state. So that potential exposure to the state would be issues that may not be in concert statewide. And I'll give you an example. Recently, there was a specification that was being changed by change order, and I'll pick on Oahu because you guys there's Oahu people here. So Oahu throughout the district was doing this change order that affected a change to the specifications. So technically they were providing statewide direction on how to solve this issue. So those issues need to be brought to the construction committee so that statewide we make sure there's consistency. It looked like there was an issue that, and to me, and Blaine, you can speak up, but that's the role of Highway CC, to keep track of all these things and make sure that everybody's kind of being consistent throughout the program. And again, the engineer should make sure they understand the contract documents, confirm the terms, and in particular, 104 and 107. 104 establishes requirements for notification, content, and time requirements. So if you're dealing specifically, 104 is a change, then make sure that they are following the proper process. But in this case, this other change I'm talking about, it really was an interpretation of material certification. So it wasn't a change per se, but it was an issue that had a statewide implication. So Marvin's asking who the construction committee is. Blaine, you might want to handle that.
The construction committee is all the construction engineers from across the state. So it's Art, Randall, Irvin, and Cliff, as well as my staff. Okay,
so what does 104 say? So some of the comments that we had in other in previous trainings was, well, we want to solve disputes, but at the very end, the contractor throws this kitchen sink claim at us and it has all these changes. So keep in mind, and this is probably one of those things we'll discuss at the pre-con, maybe emphasize, you might even do it in your weekly meetings. 104.02b requires notification. So if they're not providing notification, we need to deny the claim, deny the change. You didn't provide appropriate notification. So we really probably start needing, and I think, and chat if I'm wrong, not everybody is doing this. So oral notification is required by noon of the following working day. Written notification of a claim must be delivered within 5 days of the change condition. And look at all the things that's supposed to be in their write-up. They need the date, circumstances, source of the order. Basically, that's source of the change. Instruction, interpretation, determination that contractor regards as a compensable change, and they have to provide a detailed justification for additional payment or time. So that notice of potential claim, super important. Written notice may not be waived. It shall be precedent to filing any claim by the contractor. So if they're not, and this is something that we'll have to be educating contractors about, and that may happen during your weekly meetings or at the beginning, but making sure that they're providing notification. So at the very end, there shouldn't be any surprise about, well, wait a minute, where did this change come from? There are time limits in there. So even if they provide notification and you don't respond, then the claim is denied. Then they have time limits to file a formal claim. They can't come back 6 months later and say, oh, by the way, here's my change order. So we, I think, as the owner need to tighten up, make sure we're following these processes. If you don't respond, at a minimum, say, hey, I'm not responding, or, take that as denial, whatever. Make sure you're documenting that. Again, if it's not documented, it doesn't happen. So I don't know, Dags, for those on the line, if you're familiar with your processes in your contract, it would be interesting to hear if they're similar to this. Just chat it in there. Anyway, there's 10 working days for response. And if there's no response, it's rejected. If it's rejected, the contractor has to file a formal claim. If they haven't filed a formal claim, guess what? It's gone. So we need to tighten up this process so that, and the process is really built so that these things don't linger and they don't come at the end. So a written claim with the engineer has to happen within 30 days after the delivery to the engineer of the notice of potential claim. Failure to submit a written notice waives all rights. The contractor shall proceed with work. So again, in cases where you've directed them to do work, they have to proceed. They can file a claim, they can go through that process, but they have to do the work.
So this is where the head in the sand and the snowball starts, or could happen, right? If we're not letting them know about all these notifications, you know, it's just more problems down the road, right? And why didn't we tell them what was in the contract is going to be the question.
I think Matt had mentioned, based on his experience with some of the more problematic issues that he's dealt with, that he felt, you know, if I had talked about it in a weekly meeting and I had documented, hey, you know, this is where I'm at, just creating the trail that he had said, hey, if there's a change, make sure you're putting in your notifications. You know, that sentence in the meeting minutes, you know, then the contractor can't come back later and say, oh, well, I didn't realize, even though it's part of the contract. I had somebody mention, well, it's part of the contract. Yeah, it is. But if we continue to remind them, then more so there should be no merit or basis if it gets elevated. And documenting all of that, when you start having these meetings with your counterparts, documenting, hey, I told you 10 times. I think in this delay issue that we were having, so on Kapolei is a good example. Contractor kept saying, we're going to finish. So they were supposed to originally finish in July ahead of schedule. So July rolls around, they're not even close to finishing. So every month we wrote a memo documenting the issues and that how all those issues were their fault. 6 months later, I think December, January, they passed their contract time. So we started saying, now you have LDs, here's your LDs, here's your LDs, here's your LDs. Liquidated damages. They, in February, said, well, we're going to try to meet with Ed Sniffen, the deputy. I said, okay, fine, do whatever, but we need to resolve this. We need to move on. That meeting happened. I don't know. Ed referred them back. I mean, this is kind of where we were drafting some of this language, referred them back to the contract team, and we had to solve it. So in April or so, we wrote out how we were going to solve it, because again, they're still in LDs and time is just ticking. And then this other issue, which actually became a utility issue, an owner issue, started to happen. So there started to be concurrent delay, unfortunately. But it was really hard for them to get that overturned when we had every month warned them, you know, such of this date, we think it's going to take this long. So we think you're going to have $500,000 in LD. You know, based on your last schedule, we think you're going to have $750,000 in LD. So we just kept warning him. So I felt good that if we had to do anything, I would have had 10 memos, all of which the contractor never responded to. So I provided more than notification to them. They never responded to it. And so when they were trying to elevate the issue, they were like, well, we're not ready to meet, because they had to go back and respond to all 10 memos that they had never responded to. So that documentation, even if it's in meetings, I would encourage you. So here we are, we have a dispute. For whatever reason, we have to elevate it. This is probably the premier meeting, absolutely what you have to start. This is going to start your documentation. So you and your counterpart are going to meet. You're going to make sure you have everybody there that's been involved with the issue that can contribute to the conversation, and you're going to document. This is an essential means of documentation to keep all parties involved, informed of what the issue is. So you're going to have your memorandum of record from that meeting. That's going to start your documentation. So similar to what we were saying, it's so important to document. I think there's an impression that DOT settles, And at the same time, I think that impression is partially lack of documentation that we have as owners. And that becomes very difficult as you elevate it to say I'm right when we don't have the documentation. So it's incumbent upon the engineer to make sure we have that documentation, that paper trail. And like I said, if you have 10 memos saying something, it's hard for the construction engineer to override you when it's like, look, I have 10 memos and they haven't responded at all. You're really going to side with them? Or if you go to the administrator or deputy or whoever it might be in this process, the more documentation you have of the issue, the easier it is going to be for them, the AG's office, whoever it might be that gets involved, to settle it if the contractor truly is not correct. So we don't want to dig in and get into this game of I'm right. Just make sure you document and follow the process. So part 2, we're going to start looking at this example. So I'm going to turn it over to Alan. This is where she's going to start talking through. This is the setup of the example we're going to do as the exercise.
So this is the data that you want to include in that MFR, right? So depending on where you are, maybe you've met, maybe you haven't even met yet, but you just see the problem with the status of the information. So this is the setup for this particular exercise. The original contract is $11 million. They had 32 months to complete. So these are the time frames. There's been some changes already. You know, it's not a perfect contract. There's already stuff happening, $3.6 million worth. So there's been about a 33% cost growth. Then in looking at all of these changes, there's been some time growth that maybe was never really addressed because for whatever reason it wasn't. And now that they've seen all that and are looking at a brand new change, there's a potential 17 months that we recognize now based on reviewing the CPMs and what is left to do. So this is going to grow the contract, you know, by about 50% in time. So it's pretty significant. Okay, next slide. So here are the numbers. Okay, and this is what is setting off the alarm bells right now, right? Whether we've talked about it or just looked at the numbers at this point, because every situation is different, right? But here we've received this proposals for $2.8 million, and it included including costs for time impacts, right? And we, on the government side, have determined that 250 is our number for the actual change order itself, doing the work. And when we looked at our time impact analysis and accounted for government caused delays, because we feel like there was some overlap, and if we overlap with contractor caused delays, then we would pursue giving them time, but not necessarily money, right? So we're trying to be as judicious as possible, able to justify everything we should be liable for in this case. So our number is this $760,000 number, okay? Still 4 times different. They're 4 times higher than us. So this is a huge divide, obviously, right? So we know we're going to have to brief everybody. So let's make use of the work that we have to do by doing what is going to eventually be needed if this is a change. We know we're going to be liable, so we know we're going to do a change of some kind. So starting with this necessity part of our change order write-up, this is the information that you're going to need to brief your leadership with, right? They're going to ask, well, what did the contract originally required? Why do we have this change? So you start by documenting what you're going to use anyway in your necessity, showing pictures, drawings, any kind of description of here's the original versus here's what now we have to do because of the situation, right? And what caused it. So we want to spell out the reasons, in addition to what the change is itself, what are the reasons why we are having to do this change. So that sets the stage for your leadership and understanding, the very beginnings of this now dispute, right? And then you would be also sharing these numbers and your reasons for how you came up with your numbers, any information you have on the contractor's numbers. But of course, if you're in a dispute, there's like you don't understand where they are, right? Or you disagree at least. So whatever information you have at this time is what you're going to gather together for that MFR and to be able to present that information now as you elevate to your leadership what is going on.
So Jiro's got the contact. This is setting up the exercise that we'll do in part 2. So part of it is crunching these numbers, going through that, starting the write-up, and keeping that documentation. So I know Marvin says sometimes documentation may be limited due to shortage of staff. If those are the instances, you absolutely need to raise your hand. Because when we started this process about the documentation required and schedule analysis, and we understand there are tons of things that the project engineer and the RE are responsible for, management committed to making sure those resources were available for you to do this job. So if you don't have the resources, those are the things that need to come to the construction committee, and we need to find those resources. And there are options for that, as I was told by management. So not doing is not an option. So making sure you have the documentation is part of your responsibility. It absolutely has to happen. Otherwise, you need to negotiate a change. And that goes into your risk analysis. If you don't have time to document it, then you don't have time to fight it. So make sure that the documentation is happening. And that's what we'll do with part 2 in the week after Thanksgiving, talk about that documentation. I don't think it has to be hard. I mean, nowadays you can record conversations, and at a minimum, at least you have a recording of what happened. And ideally, we have some kind of junior person that can document things for you. I mean, that's what I would be advocating.
This information is just the preliminary information where you see you've got this huge divide. You know you're in for a fight, right? So it's a dispute. And so in that very first part of the procedure where, you know, you want to send these emails, right, to the leadership, they might just say, okay, so you've got a big fight ahead. We get that. And you're just letting them know where things are, right? As you gain more information and you're better able to recommend, you know, a decision or a solution, then that might require that sit down with them. But this level of information right now, what are the statistics of the contract? Where are we at? The basics, right? And what is the actual controversy? It's that difference in our proposals. And then why do we have this change, right? Why are we where we are? So you don't have all the answers at this point, but you're preparing enough to give a heads up to the leadership. And they may want more, and you may not have more yet. But then that is at least that initial stage so that nobody's surprised, right? We're doing all of this as we're working through the final resolution of the situation. So we're not waiting till the end. So just because I'm showing you this form that is part of the change order doesn't mean it's when you're writing up the change order. We're just saying start with the end in mind, that eventually you're going to fill out this form. So these are the pieces of information that you now already have, right? You know why you have a change. You just have not finished getting to a settlement.
And so that's where I know, you know, we've talked about changes coming. That's part of this, is contemporaneously documenting the things that are going on. These things need to be in the backup change order log. It was clear through the COCOA review and as discussed at the construction committee, which again is comprised of construction engineers through the state, that we want to have more detail on what should be in that backup folder. And so that'll be a future module discussing that negotiation record, what it looks like. We had an opportunity to brief Federal Highway yesterday, so don't be surprised if Federal Highway doesn't start asking for these same things. So we're looking for that program alignment. And they're very empathetic on the status that we're at now, but saying we can't do it because we don't have resources with the pipeline the way it is, probably not going to be a good excuse. So let's elevate that and figure out how you can get the resources you need to do the job that you're doing. It may be having that CS support, and maybe it's not for the entire project. Maybe it's just for documentation.
And that at this early stage, when you know you've got this kind of a divide in having to figure out how we're going to get a settlement when we're 4 times different, this is a time where we might have to say, this is what's going on in our office right now, and we need additional support because there's a lot of work yet to be done on this. So this is a way to get that support.
And we just can't wait until the very end to do it. And so that's where, if you're having those challenges, talk to the engineer, have that issue elevated, and so we can figure out how to get that support. Okay, so that's the intro to the exercise. We'll go back to the dispute resolution policy and procedure. So again, we had the meeting with the contractor. We had everybody there. We created the memorandum for record. Now we realize, you know what, we're too far apart. It does not look hopeful that we will be able to settle this. So you have some realization at this point, and I think this goes back to Joy's point. You have to understand when to elevate it. This has been a little more prescriptive in how that happens, just because this process has been so informal, but we anticipate, as you're enforcing the contract terms, where you're looking for the schedules every month, where you're looking to baseline things, where you're looking for safety plans updated as appropriately, where you're looking for change order notifications that aren't happening. You may have to do this all the time. So that's where it'll be interesting if you have these disputes that keep going on for more than 2 weeks, as that gets elevated to everybody. I think one of the district engineers was concerned, do they understand how much email they're going to be getting? But this is the direction that came from George and Ed, that the engineer should brief the construction engineer and the district engineer immediately, and that the district engineer, upon that notification, notifies the administrator and deputy immediately. At this point, the project engineer, the resident engineer, construction engineer, district engineer, highway administrator, and deputy should be included in all communications regarding the dispute. So I think this is a big change from how you're usually operating, that you're keeping Art informed, but the direction based on, sorry, I keep talking about Oahu District. You're keeping the construction engineer informed, but this is saying you keep everybody informed as that thing elevates and keeps going. Now, the comment that came back from George and Ed is they may not get involved, but at least they can see something's happening. And that was the comment that came from the district engineer. Do they understand how much email they're going to get? As it stands now, this is what was discussed with management in order for them to support solving the issue at the lowest level. And so we'll see. It's been a month. I'm sure they haven't gotten overwhelmed just yet, because this is the last of the training classes. And I wasn't sure if everybody kind of read through the process that we're now following. But this is a process, okay? So once that happens, the engineer should make sure they have documentation for the meeting with the contractor. So again, we're not in a formal claims process. These issues may not even be claims or changes. It may be an interpretation on a permit. We were recently involved with that kind of miscommunication that was going back and forth for months. It may be an interpretation on material certification. That's an issue where you have a formal claim. It's this kind of gray area. And so if the contractor is not required to provide that information, the engineer will require that information. So it goes back to Marvin's point. We have all these things and we have limited resources. We've heard that over and over and over again. We get it. If that's an issue, raise your hand. Talk to the construction engineer, because not documenting it was not an issue. If you're not getting monthly schedules, that's not necessarily a change, but it's something that's consistently happening. We can't let it happen. You might have to elevate those issues. So you have to start preparing that documentation. That goes back to the exercise. It goes back to the requirements. And I really like the information that's included in 107. So again, even if you're not at that point, this gives you some really good guidelines to put into the backup that you're documenting. So a detailed description of the facts and circumstances, dates, locations, items, the specifications that are required, other documentation that supports the issue or the claim. If it involves time, what are the specific days and dates, the reasons, special provisions, any detailed analysis or impact to critical path. All of these things should be in your write-up. And I think this is the other thing that kind of goes into our next module, which has to do with diaries. Within 107, it says additional monetary compensation for the claim cannot be in an amount greater than the contractor would be entitled to under 109.06, which is your special provisions. So that makes it very important that the diaries have all your time and equipment and material costs, quantities put in place so that you can recreate that record. One of the questions we had was, oh my gosh, you want us to do force account sheets every day? No. But the diaries, which is your mechanism to understand who was there, what was there, including equipment, idle or in use, you need that information in the diaries. Because if you had to recreate what is the entitlement for the contractor, it's going to come from this. We'll have another discussion on this because overhead and time delays is not really addressed in your contract. And I know I had a discussion with Art on what the entitlement is. So I think at a working group level, at a construction engineer level, we have to have that discussion. What does time look like? What are you going to be putting in there? So this is the beginning of the documentation. Alan alluded to it. So we're back to the exercise.
So again, right, this is not a dispute yet. And so you're asking yourself, why do I have to get all this information together if I don't even have a dispute yet? You know you're heading toward one. So again, this is a proactive way to start with the end in mind. And not only will it help you prepare to brief your leadership, but if you're looking at this list early on, it helps you also work through your own decision. Have you checked everything? Have you considered all of these things? Is this something that maybe you should now take a look at? So,
and I'm going to correct Alan, because at this point you do have a dispute. If it's an issue that has gone on for more than 2 weeks.
But this is part of the claims process. Yeah, yes. So it's not a claim. It's not dispute, a claim. Not a claim. Yes. So I'm just saying that when you're heading down this road, you know that this is the end result, that this is the kind of package you're going to put together. So these are the things that you should consider as you're trying to form your position on what is the right thing to do. And if you've missed any of these things, take a step back, try to consider it and see what impact it does to your position.